I call this council work session to order, and let the record reflect that all council are present and accounted for. If you would, when you're ready, read item number 1.
Discussion of proposed code amendment, amending Chapter 3 of the Surprise Municipal Code by amending Section 3-15 and adding Section 3-18 and Sections 3-70 through 3-78 regarding meet and confer.
Okay, before we go into that, I realize that I skipped over the call to the public, which is at the beginning on work sessions. Is there anybody from the public that would like to speak?
Yes, Mayor. Bob Vukanovich.
Ready to be right away.
Sorry. Well, Mayor?
There's no paperwork on this, so I don't know what you can talk about. Hopefully I can talk about the 212 budget, can I? I got Mayor Lynn Truitt and council members. A few questions on the 212 budget discussion being held tonight in the workshop. Unfortunately, we are not given any paperwork on your agenda item. Presentation and discussion regarding the fiscal year 2012 budget, including update, capital improvement plan, and potential interfund loan refinancing. I will use the fiscal year 2012 city manager recommended budget in addressing the operating reserve fund that has been in place since the year 2000. Under the major issues, it states that the fund balance of the city's operating budget was reduced by $5.6 million. That's in your budget this year. As a result of the corrections, and the 2-month operating service was not fully funded at June 30th, 2010, well, the 2010 budget. Now, I don't understand what that means. It says that's a paragraph. Under the major issues, it states that the fund balance of the city's operating budget was reduced by $5.6 million as a result of the correction, and the 2-month operating reserve was not fully funded. So I don't know what the bottom line of that is. In the 2010 budget that was approved by council, says there, and I know because I addressed this before the council, so I know that how much money we had. You guys keep referring to 13 million, and it's not 13 million. In a budget, it tells you just what I thought it was. Reserve operating reserves of 27.4 million are set aside to offset fluctuation in operating revenue sources which are most susceptible to changes in the economy. Reserve balances are equal to 2 months of operating revenues, of operating funds, and 1 year of debt service payment for debt other than general obligation. In the approved 2011 budget presented by ICM Mark Coronado, it states that in the reserve budget funds were set aside. And he says the reserve operating reserves of 18.4 million are set aside to offset the fluctuation in operating revenue sources which are most susceptible to changes in the economy. So again, I don't know where you guys get that 12, 13 million. I don't know the 5.6 where you're short unless you borrow, and I think I got documentation that you borrowed out of that fund. Okay, so then you go down here to the 2012 budget. On page 3, operating funds has not been programmed for 2012. I guess you're familiar with that. The operating funds has had to make interfund loans and is also cash short. I didn't know we were borrowing on that fund because that was specifically put in there for a specific reason, and we're borrowing against it. So in the same budget where you say that you're not going to make operating funds available, on page 342 of the same budget, reserve funds will be maintained to ensure the continued delivery of city services. The operating funds reserve equal to 2 months of annual budget operation expenses will be maintained. So now you got two things. You say in a budget you're not going to fund it. You're also saying now that you're going to fund it. So there's got to be some kind of clarity to this stuff. Another thing that should be looked at, I don't know if you noticed how we inflated some of the departments in year 2011 budget. So now we're decreasing the 2012 budget where it makes it look real good, but in reality, our budget this year, 2012, is higher than 2010. You inflated the 2011 budget, now you decrease, so you got all the minuses and everything like that, but in reality, it's more than it was in 2010. Okay, I have a solution to our problem, but I don't believe that the city could handle my solution. So, and then I don't know if you noticed, did you notice how some of these departments have increased? And one department increased by 27 employees, I believe. And when we had Randy Oliver here, he was going to reduce that department, and all of a sudden, that department's got something, I believe, 27 more employees. So I just want to bring this to your attention. But this clarity on this here, ambiguous, where you have this, you have that, how do you determine? What are we actually doing here? I have one suggestion, if you want to listen to it. I would get a bonded, certified public accountant firm and let them for 2-3 years take care of our books.
Thank you.
Because I think we're in big trouble here.
Thank you, Mr. Vukanovich. And,
Thank you.
I apologize because I was in error. There is, the call to the public actually is item number 3. And so hopefully some of your questions will be answered as the presentation is being made. But in order to be fair with everybody, if there's anybody else from the public that would like to speak, I will allow them to come forward, but I will, at item number 3, reopen it to the public.
Okay, well, it's number 3 on the sheet that I gave to Linda. That's 3.
Thank you. Is there anybody else in the public?
Yes, Mayor. Brian Moore.
Ryan, do you want to speak now or after the meeting or both?
Mayor, if I could speak at item number 3 as noted on the agenda.
Okay, very good. Thank you very much. I will close the call to the public, and we will go to item number 1. My apologies.
Mayor, Council, we're here tonight to go back over the meet and confer ordinance change that came before you initially on the 26th of April, just to make sure that you understand both where that's going to fit in the code and why the changes are being proposed, and to better go through the actual provisions itself. Additionally, we want to make sure, because there was believed to be agreement amongst the Fire Association, the Police Association, and management on the 18th of April, and subsequent to that, the city management got a copy of some additional changes, that you understand what those changes are and management's positions with regard to those changes that were submitted by the Fire Association.
May I just kind of ask a question?
Sure.
Why didn't the council get this item printed out in our books so that we would have an option to look at it? Even though it's items that have been discussed before. As you said, there has been some changes. Management made some changes. That even is more imperative that this council and the mayor receive this information prior to a workshop. Now, I don't know whose fault that is, but that is a problem. Which brings up another issue, and that is we need, because the change of Tuesdays from Thursdays, we cannot accept council books on a Thursday night. You've shortened our review period 2 days. If you're going to have a council meeting on Tuesday nights, we need our council books on Tuesday previous. What's been asked before, but staff has never responded. That being said, go ahead with your dissertation, okay? But I am very, very disappointed in staff that we did not have an opportunity, nor the citizens, to review this prior to right now.
Mayor,
Before you go ahead,
Council, may I make a
recognize
comment?
Mr. Bailey.
The information that's being presented to you is not new information to you, and it's not new information to the associations, and it's not new information to the public. There has been a workshop, and there have been items where this has been presented to you. And what we're doing tonight is we're providing a review based on the feedback that was provided to me that goes through and fills in some of the blanks that may have arisen when this was originally presented to you.
Who
So
gave
this-
you that feedback, Mr. Bailey?
By no means should this be a surprise.
Who gave you that feedback?
Members of council. So this should by no means be a surprise to anybody in terms of what we're discussing.
It is a surprise in that Misty has already said that there's been some changes done by management. We have not seen those changes by management.
And this is a workshop. We're not
Yeah,
approving
but
it
give
right
us a
now.
break. Let us review it before we come here. That's all I'm saying, okay? You're in the wrong. I don't appreciate it, and I think
It will
there's
be our
probably some other
expectation then,
people.
council member, that you read all the ordinances that we provide to you.
And I represent the council, okay? And I think if you were to poll the council, they would have an issue with that as well.
I do not recommend you poll the council.
You know, I
council
think that
member.
this discussion has gone far enough. Mr. Alton has made his point. We hope that everyone can understand the frustration, and perhaps we can do something to facilitate getting this information earlier than what we have this evening. But if you will, please go forward.
Thank you, Mayor. Mayor and members of council, we did want to back up a little bit and provide a little bit of background information, specifically to make sure that you understood that the meet and confer ordinance that's being proposed is, in fact, intended to go into Chapter 3 of the City Code. And as you may recall, Chapter 3 is a relatively new code. It was adopted in, I believe, 2009. And it contains several items directed at personnel and establishes city council policy with regard to personnel. Specifically, it establishes the city manager's duties and obligations regarding personnel, your general policy, categories of employment. It discusses benefits and compensation policy. It also contains a corrective action and appeal process for employees who are disciplined by city management, and that included a personnel appeals board that you created to hear appeals from discipline of employees that varied anything above 24-hour suspension. It also identifies holidays and the types of leave other than PTO that can be taken by employees. So meet and confer, when it's codified, will go into Chapter 3. And understanding that, part of the things we're going to discuss tonight is how that works with other sections of Chapter 3 so that we don't unduly repeat ourselves when it comes to discipline, which was one of the topics that was discussed significantly at the last workshop on the 26th. We also wanted to make sure that you understood what meet and confer is and what it is not. Meet and confer is a formalized process by which employees can meet and discuss items of concern with management through employee representatives. It is not collective bargaining, it is not mandatory, and it is at the discretion of City Council. In other words, having meet and confer is not obligatory on the part of the city, but rather it is something that you as council can establish as a policy in a manner in which to facilitate communications between employees and management.
Mitzi, excuse me, I hate to interrupt, but, and I agree with what you have here. It's not collective bargaining, it's not mandatory, it's at the discretion of the city council. However, it appears in the past with changes in city management, city manager, changes in human resource director, we get changes, or the fire department, and I have to assume the police, I'm not that sure on there, but that things are changed in and out so that it's like every year. It's an annual type thing where you might have it this year, not next year, but maybe the year after, because you've got, we've had some severely high turnover.
What's the point?
Pardon?
What's the point, Mike?
Well, the point is that it says meet and confer is not collective bargaining, and I'm saying that I believe it should be. They shouldn't have to go through meet and confer every year. That's what I'm saying.
And The frequency at which meet and confer is utilized is really up to council. I think one of the recommendations was that it go to every other year, and we'll discuss that this evening. Collective bargaining tends to be something that's referred to that is under the control of the National Labor Relations Board, and that is a federal law that applies to private union agreements. In the public sector, it does not apply, which is why it is not collective bargaining. But it is a process that formalizes communication between representative groups and management. So it's kind of the public sector version, so to speak, although it's less binding than collective bargaining would be. I also wanted to make sure that you were aware of the history of meet and confer in the city of Surprise. It was originally adopted in 2001 by an ordinance, thank you very much, by Ordinance 0102. It created representation through a petition that was signed by the majority of individuals who were represented by the organization, 50% plus one. And there are 3 organizations that are identified, or groups of employees identified in that ordinance. They are the Police Employees Association, the Fire Employees Association, and then basically everybody else that's not management, primarily at City Hall and Public Works. It also had a joint recommendation of action, which was received by council by motion, and it was amended in 2006 to change the dates that it occurred to December 1st and ending March 1st. The current ordinance refers to an outdated compensation schedule. It is not included in city code, which has caused problems because when people want to see our meet and confer ordinance, they can't find it. It is inconsistent with some provisions of Chapter 3 because Chapter 3 was adopted after the meet and confer ordinance. And it does not sufficiently define employee and management rights and expectations with regard to the meet and confer process. And that is the reason that meet and confer is being brought to council for discussion and ultimate, hopefully, adoption into the city code. The goals of the proposed amendment would be to update and clarify your policy with regard to meet and confer. It brings terminology in line with Chapter 3. It better defines the process and establishes the workable deadlines, and it defines the employee and manager rights and expectations, and most importantly, it then includes it in city code so that residents and employees have easy access to the ordinance itself. The proposals in this particular process, there were competing versions, and those versions were combined and merged into a single document that was discussed amongst the parties of interest on April 18th, and that would include the Fire Association, the Police Association, and management. All the terms of that proposal were agreed upon with the exception of who should serve as the mediator. Subsequent to that, on April 25th, management received additional language and some additional requests for changes from the Fire Association, and the council was held the very next day on the 26th. So we're going to go through them. They're not going to be necessarily in order because of not only the changes that were recommended, but also just to give you a better idea of what was agreed to and what wasn't, and moving forward.
Misty?
Yes.
Excuse me. As you go through this, could you point out what the management's new terminology is?
It is absolutely pointed out for you, sir.
Thank you.
Section 3-18 would be a new section. It has to do with the supremacy of Chapter 3. And basically what it does is, whether there's an ordinance, a policy, a procedure, it doesn't matter. Chapter 3 is going to rule over it. If there is another section in the code, another chapter in the code that is inconsistent with Chapter 3, Chapter 3 will be superior to it. That includes any memorandum of understanding that is ultimately agreed to between management and the associations. Subsection 3, and this is going to be one of those changes that you just referred to, sir, Councilmember Alton. Subsection C currently reads that a determination of whether a conflict or contradiction exists would be determined by the Maricopa County presiding Superior Court judge or designee, and those decisions would be final and binding on the parties. In reviewing this ordinance after those changes were agreed upon, we're going to recommend a change, and by we I primarily mean the legal department, to affect that paragraph. Specifically, to change it to determinations would be made by obtaining a legal opinion from a retired superior or appellate court judge, the cost of which will be paid by the city. And the reason for the recommendation is that the only way to really get that kind of a conflict in front of a sitting superior court judge would be to file a legal action, which is not doesn't inure to the benefit of the employees, the organization, and it's slow. By using a retired judge, it's still a neutral party, it's somebody who's familiar with interpreting law, but yet it's quick, and if the cost is paid by the city, it's very clear that we can get that resolved very quickly and move forward. So that is the recommendation, and so at this point,
Misty?
Sure.
We spent a lot of time talking about arbitrators and mediators 2 weeks ago. And I thought we had agreed that it would be an arbitrator, didn't we? Or a mediator that was going to be picked out of the arbitration pool.
And that is correct, and that is what the ordinance says with regard to resolving meet and confer disagreements. This
Okay,
would
and
not.
this is only when people get terminated?
No, this would be a conflict between, for example, if the city manager passed a policy or procedure that was in direct conflict with your Chapter 3 of the code, and that issue was raised and there was disagreement about whether it conflicted or not. This gives us a mechanism to get a decision interpreting law by someone who normally does that, which would be a judge, to decide whether or not that policy or procedure actually contradicts your Chapter 3 of the code. So this is separate from any disagreement that would be resolved through mediation, and we
Okay.
did include that provision at the direction of council.
Okay.
However, this is a change, and because we lacked consensus on this kind of change before, if you guys could provide direction of whether this kind of change is agreeable, so we can include it in a proposed ordinance.
Misty, was this change discussed with the employee associations?
This change is being recommended by the legal department after reviewing the ordinance as presented on the 26th in light of the direction that was given by council. So, no.
You have not had any discussions with the fire and police associations?
They had agreed to the previous language of using a sitting judge. As we reviewed it from the legal department's perspective, there was the problem, as I noted. And so we were recommending using a retired judge instead of a sitting judge for that reason.
Okay.
Mayor and council, if I just make, to clarify the point, the reason being, and it goes to Misty's point, is that to get a sitting Superior Court judge, one of the parties would have to file a complaint. And so in terms of a relationship moving forward, I don't think it would behoove any of the parties that if there was a disagreement as to what the meaning of a certain term would be, was to file litigation, that then it would be a complaint, the association against the city or the city against the association. What this provides is that to the extent that we need an interpretation of a term, we understand and we go get that interpretation.
Okay. The next section that we want to go over is Section 3-70, which is basically who can serve as employee representation. This language was agreed to by all the parties on the 18th, and there is no change being recommended by the Fire Association in their subsequent submission. I did want to point out that subsection B, 1 through 4, has specific terms formalizing what an organization, an employee organization, needs to have. And these are important to understand. It requires that the name and address of the organization, the charter, constitution, or bylaws, the names and titles of the elected officers, and then a statement that they're not going to discriminate be provided to the city manager. The reason why that's important is because if it's just a club of employees that are not formally organized, it makes it very difficult for management to know who they're actually supposed to be sitting at the table with. So this is a change from the former ordinance, and I just wanted to point it out because it wasn't specifically pointed out.
Misty, you had indicated earlier that there was 3 different organizations.
There's a possibility of 3 organizations.
No.
Well,
There's 2
currently.
organizations in
Correct.
place right now, so don't say 3, okay? What I'm hearing is you're saying 3 and you're alluding to 3, all right? But in fact, one of them didn't renew.
In point of fact, the meet and confer ordinance allows for 3 separate organizations, 2 of which actually exist. One is
Okay.
simply a possibility, but it could, if they went through the petition process under the current ordinance, get an employee.
But wasn't it true that they had been in existence and they chose not to re-up?
There was 1 year where I believe AFSCME, which I couldn't tell you what that stands for off the top of my head, came in and did represent the non-public safety employees. But
Right.
you're correct, they did not renew their certification. But
Okay, so theoretically, we only have 2 associations.
we have 2 currently certified, yes.
Okay, thank you.
Okay. But just to be clear, there are 3 possible groups.
Yeah, there probably could be more than that.
Under the ordinance, there could only be 3.
Okay.
So subsection B, I just wanted to make sure that you knew that it does require a degree of formality that did not previously exist in the previous ordinance. Subsections C, D, and E also talk about the employee representation. And I wanted to point out subsection D in particular to make sure that you understand what the meaning of this provision is. And what it is that once an employee organization is certified under this ordinance as it currently is permanent. Currently, the ordinance, every 2 years, is a recertification process. Under the new proposed language, it's permanent unless the employee organization is decertified. And we'll talk about that in a little later.
Misty, I'm sorry to ask you so many questions.
That's okay.
But if it is certified, it's certified for life.
Correct.
All right, but what if the employees opt out? Do we get a feel for how many employees belong to the association then versus at the beginning?
That's a very good question, and it's an important thing that Councilmember Williams had brought up on the 26th. And one thing that you need to understand is that once an employee organization is certified as representing an employee group, they represent the entire group, whether or not the employee wants it, whether or not they pay their dues, whether or not the employee takes the benefits of that group. They sit at the table and negotiate on behalf of the entire group. So there is no opting out in that respect.
Why are we doing this?
It's really up to you if you want to do meet and confer.
Well, I believe in meet and confer, okay, for the 2 associations that are currently in place. However, I do have a hard time, and meet and confer the way it was, okay? But I do have a hard time for life.
And that's great direction. If that is something that you do not as a council want to see in the ordinance, we do need that direction to make a change. The current ordinance has a recertification every 2 years.
Have both associations agreed to this language with management?
Yeah.
The permanency was subject to negotiation, and I will say that during the negotiations, everybody gives up something, and so this was agreed to by the parties on the 18th, yes. But it is your ordinance.
I'm fine with it as written.
So in the lack of hearing any changes in this is the language that's going to be in the ordinance when it's presented for vote.
Also, is that vote 50 plus 1, or is it?
No, it's not, and we will get to that in a little bit because I will need additional direction from you at that time. The other one that I wanted to make sure that you knew about was subsection E, and this is important because this is the grandfather provision. In the current version of the ordinance, this makes any organization that is currently certified automatically in compliance, and they don't need to recertify under this ordinance. Both the Police Association and the Fire Association are currently certified. They would be subject to renewal, I believe, this coming year. But if this is passed, because they were certified as of January 1st, 2011, they would then be permanent unless they are decertified, which we'll talk about in a little bit. So you need to understand that. So if there is any change, we're assuming there's not unless you tell me otherwise. Based on review of the changes submitted, the legal department is making a recommendation for a small change. And that change specifically is in relation to 2 things. One is subsection D on the decertification. We'll get into this a little bit later, but there was much discussion, as you recall, on the 26th about when and if an employee association can be decertified. There is a formal decertification process through election that's contained in Section 3-73. We are recommending that that section pursuant to Section 3-73 be removed from subsection D, only to allow the possibility, if there are other circumstances that you as council want to decertify an organization, this would allow it to apply across the board. It does not change the grandfathering provision or the perpetual certification. at all. It simply allows flexibility on your part without monster revisions to numerous sections of the code. The other provision that we're recommending is, remember those 4 sections that I talked about that formalized the organization, the name of the organization, the charter, the bylaws, the elected officials from the organization, and the statement that they're not going to discriminate? We would like you to include those as a prerequisite for earning grandfathered status, and this would give the associations through July 1st. If they don't have those things, I believe they do, but if they don't, it would give them a little bit to get them, and it would still allow them to be grandfathered. But this would just assure that the city manager knows who he's supposed to be sitting down with at the table during meet and confer. And again, this is a recommendation based on legal review, so it has not been run past the associations. If nobody has any problems, I'll assume that you want it in the proposed ordinance, and we'll move on. The next section is employees who can participate, and this goes to the 3 groups, Councilmember Alton, that you had mentioned earlier. They are the police officers, the firefighters, and then basically everybody else in City Hall who's not a supervisor. And this is taken right out of the current ordinance. It's nothing new. There is a small exception in subsection B, subsection 2 there at the bottom where it says no classified employees. Chapter 3 currently differentiates between classified employees and non-classified employees. Classified employees are subject to just cause termination. They have the right to appeal under the code. Non-classified employees tend to be supervisors, elected officials, appointed officials, and so forth, and they do not have those rights. The original ordinance makes a long list of employees who are not subject to meet and confer. Most of those are non-classified employees. So this change that's being recommended, it goes hand in hand with the changes that are being recommended in 3-15, and that's to modify who is a non-classified employee so that everything works together, so we have the right people sitting at meet and confer negotiating for the right employees. And just to bring to your attention those changes, subsection C there, all employees in the office of the city manager. It currently reads assistants. Assistants is somewhat vague in that. Does it mean secretarial staff? Does it mean a project coordinator? And we don't have anything built into the ordinance to allow changes in staff. For example, if you were to bring on an assistant in the city manager's office to help coordinate communications with council, for example. The current ordinance doesn't allow for that in the sense of non-employee or non-classified versus classified employees. So we're recommending that all employees in the office of the city manager, and these were changes that were agreed to, by the way, by both associations in the meeting on the 18th. The other one is to add the promotional trial period employees. That's consistent with current policy and practice. The next thing, which is most important to you, would be to add to non-classified employees all employees in the mayor or council's office. And right now you have executive administrative assistants who are already excluded. But should you choose in the future to add staff, whether it's a project coordinator or other kinds of assistants to you, this would make sure they are not subject to meet and confer. And why that's important is because ultimately, any dispute on meet and confer is going to come back to you. And if you had employees who could negotiate in meet and confer, it might be perceived as a conflict of interest or impropriety. And so we're recommending that those just simply be placed in non-classified status. That also makes them at-will employees. So if you're dissatisfied with their service for any reason, you can let them go. For those same reasons, all employees in the Human Resource Department would also be added to this list. Again, this was all changes that were approved by both the associations during the meeting on the 18th. The next section that we want to review very quickly is the employee rights. These were not really subject to any changes submitted by the Fire Association on the 25th. They were agreed to by the parties on the 18th. It just sets forth those rights that the employees have. I'm not going to spend much time going through them unless any of you had questions from your previous read of them or any questions today. We are recommending one change to this section. Subsection A, currently at the end of it, includes a violations will necessitate corrective action. And this is a legal department review and a recommended change. We're recommending this change because corrective action has a very special meaning here in the City of Surprise, both in the city code and our employee policy manual. Corrective action means a course of progressive discipline that will ultimately lead to termination if behavior is not corrected. By requiring it, by saying violations will necessitate corrective action, first and foremost, we're including corrective action in a section other than what it's currently in the code. It's a different section already in Chapter 3. And it also requires that no matter how small, no matter what the circumstances, an employee who has deemed to have violated this subsection, which if you read it, if one employee were to say to another employee, I really think that you need to join this association because if you don't, you'll regret it. That could be perceived as a threat or an intimidation. And if that were to occur here under the way that's currently worded, that would require corrective action, whereas under city policy, that would first require that the employees try to work out their own problems and differences, and that secondly, management be allowed the opportunity to counsel and work together with employees to maybe better educate them to understand how words can be interpreted or perceived. So this is a very harsh requirement that is a little bit inconsistent. And I know Councilmember Hall, I know you were one of the council members that had talked about wanting to make a case-by-case basis of, you know, what consequences an employee might have. And Mayor, I believe you were as well. So that kind of feedback was one of the other reasons that we're recommending this change. So if I don't hear anything, we're going to go ahead and move forward and taking that language out. Subsection C, D, and E, again, just talk about the rights of the employees, and those weren't changed at all. Subsection 3-75 talks about city management rights. These were not subject to any recommended changes submitted on the 25th by the Fire Association. They were agreed to on the 18th by all the parties involved. And there are no, sure.
Can we back up a little bit through the last item? Have you had any discussion with Fire Association and Police Association regarding these changes?
Regarding the changes of taking out for example, taking out violations will necessitate corrective action. That language was put in, I believe, as a result of negotiations that occurred on the 18th of April. However, the legal department again reviewed it, and we're advising you of how it conflicts with current Chapter 3 and how it also.
How does that set with the two associations?
I'm sure if Ms. Moore would like to come up, she's sitting right here, and I don't have any problem at all with her addressing that.
Can I back up from the very beginning?
Sure. Could you move the mic up a little too, please?
I was just given this packet this evening at the same time you all received it. And I'm having a hard time following it because it's not in the format that we've been working with. So I'm trying to page through and make sure that everything's in line. The last change that we're talking about here, as far as having the corrective action, that's something that all three have agreed upon. The city agreed upon it in our meeting. Fire agreed upon it, and also police agreed upon it. So we feel that it's important to have it in there because it protects both sides, whether it's an employee or whether it's management encouraging or using coercion or something like that against an employee. We feel there should be some kind of action taken.
Julie, you said you were going to go back from the beginning. Do you have other issues? What was presented to you tonight?
Really? I guess I would have to start at the very beginning because this packet that I've been given is not in order. The numbers aren't even lined up with the packet that we had been working with. So if I could have a second here and start to get through it.
You know what I suggest is that none of us had seen this before. And my suggestion is we table it for 2 weeks. So we all have an opportunity. And if you could put it in the same format as the guideposts that you have been using, they have been using, police have been using, put it out.
Could I add to your recommendation as far as maybe we could have a meeting with Misty and make sure that we're finalized on our agreements, because I feel that they've changed their mind and brought forth some changes that we have already decided upon. So I don't have my notes and my backup to defend everything that we've already decided on.
I find it very odd you know, and I know, Misty, that you're trying to do a good job for us to understand the whole ordinance, okay? I appreciate that. But again, I have an issue with just receiving it, and I think we need some time to review it. And then you got to work it out with the associations first.
If I may, Councilmember Alton, the order that is in the presentation is largely so that you can process all the contents of the ordinance in a way and make decisions. We would have an ordinance that would be in order, which is the same format that they've previously seen. The changes that are recommended were either at your direction from the 26th, which may be different from what the city manager and their representatives had agreed with the associations on the 18th. And I would like to point out that there was agreement on the 18th, and there were subsequently changes made by the Fire Association that we need to go through so you understand how those differ from what was agreed on.
Yeah.
If it's the direction of council to come back in 2 weeks, I have absolutely no problem.
Well, I'd like
in
to
doing
finish the
that.
workshop, though.
Are you going to be looking for a consensus tonight?
I want you to be educated tonight so that you can make an informed decision, sir.
In 2 weeks?
If that's your desire, then we can do that as well.
Okay.
I'd like to get through the workshop, as
Right.
Vice Mayor said, and then I would encourage you to sit down and get that final product with the associations prior to an agenda item that we would take action on, and that before bringing that forward.
Absolutely. This is primarily to get better and clearer direction from you on some of the topics that you had
Go ahead.
discussed.
When we do come back, what I would like to see is where there was an agreement on the 18th, where we as council changed it, and then changes recommended by staff, and then delineate any further discussions and disagreements with either association. So that's like a 4 or 5 tiered cake, but if we're looking for clarity, that certainly should bring it.
We can absolutely do that for you, Mayor.
Thank you.
Okay, thank you. Thank you, Judith.
Could I have one more comment, Mayor and Council? Since we're talking about changes, and the city has proposed some new changes, I'd like to go back to, this isn't numbered, but page 315, or section 315, categories of employment, under non-classified employees. And I'm not an attorney, so some of this stuff, it just takes a little while for me to digest it and understand exactly what our legal department is coming forward with. But one of the changes that they added was letter G. It says classified employees in their introductory, and it's underlined because it's a new clause put in, or promotional trial period of employment.
You know,
That's-
Julie, unless or until we can all find where you're at.
Oh, I'm sorry.
Because this might not be in our
It's on the
presentation.
screen.
Oh, okay. Not on mine.
Presentation.
That language was in the 18th agreement.
Okay, thank you.
Right, but since we're talking about changes that the city would like to see, I would just like to mention this change that fire would like to see. The city added in or promotional trial period. That would include, let's say, a 10-year firefighter that's going to be testing for captain. They go through a 1-year promotional period after they're promoted. So now suddenly they become a non-classified employee. According to our employee policy manual, under categories of employment, it's policy number 2.3. The only employees in there are fire and police cadets, which is the wording in the beginning, the classified employees in their introductory period. So I'm just saying that putting that into our ordinance is a direct conflict with what is already in our policy.
I believe the
So I would
intent
like to
was.
bring that up.
I believe the intent was for probationary period.
It's the
Okay.
probationary trial
But can you
period
see,
of promotion.
can you see that
But for
a promotion
promotions?
or getting a new position within the city may have a bad effect?
I'll give you an example. A demotion, which would be, for example, if an employee, and since the example was given was fire, if a engineer is promoted to captain, and in their probationary, they're put in a probationary promotional period, because if they can't hack it, and management decides that promotion was an error, a demotion is discipline subject to appeal and must be based on just cause. By including that period of time that they are promotional trial period, their probationary status in the promotion, Excluding that from the classified status means that management has the opportunity to move that employee back down without having to go through the Personnel Appeals Board.
Well, I think you can word it that way, okay? I think, and that's in rare cases, that somebody doesn't cut their new position that they've been promoted to.
Right, that's why it's promotional trial period.
Yeah, so what I would suggest is that legal staff, in all of its wisdom, come up with some different wording that addresses that particular issue. But let's not throw the baby out with the bathwater, number one. Number two, we have to have, I would like to see a promotional ladder capabilities within the city of Surprise, advancement ladders. If people are doing the job and they qualify for promotion, they ought to get promoted rather than hiring somebody from the outside, okay? And so I think this kind of squelches that. I think that we, because there's really no incentive. If they're going to be on probation for the new job and they have no capability of using their association powers, it doesn't, why do it? I mean, everybody that gets promoted has a thought in the back of their minds, am I going to be able to do it?
And we will come back with some language that hopefully
you.
will be satisfactory.
Thank you.
And just one point, we would like to see the wording so that promotional trial period is taken out and that person does not become a non-classified employee. We would like to see them to remain as a classified.
Maybe the language.
Mayor, do you understand the ramification? Because then, to the extent the individual does not meet the qualifications, that becomes an act of discipline that goes before the Personnel Appeals Board.
Right, and that we have to prove just cause, right, for that.
I wonder how that's, I wonder how that serves the employee, quite frankly, if the employee would really even want to go before a Personnel Appeals Board to have his lack of qualifications or abilities, his or hers, publicly discussed. I just don't know. I don't think I would, if I'm not cutting the mustard.
I'm sure we can come up with a
But they
solution.
wouldn't have been promoted had it been different.
Well, possibly but you're suggesting that we promote from within, and I don't disagree with that at all, Mr. Alton. But if we're doing that and we're eliminating our ability to go to the best candidate available, then we might find ourselves more often in that position than we would like to be. That's my thinking.
Didn't we have some real world happenings to that regard, like in the fire? Didn't we take a captain that was promoted and move him into another position?
Two things. First thing is I think that discussing
Or the fire chief did.
Yeah, we're kind of getting far afield on what's agendized today. I have heard what you guys want as far as options and discussion, and I think that would be a thing that we might want to put on a future workshop, and I'm sure we can come back with some language or at least some options on language for a thorough discussion on how we do promotions and when those promotions are subject to appeal and not appeal. And I've made a note of that, and we will bring that back to you.
Okay.
So we had talked about management rights, that the new ordinance establishes, though the previous ordinance was silent on those matters, and that they were basically in agreement, and so unless you had any questions, we were going to move on. And this brings us to the petition process itself. The old ordinance was, or I shouldn't say the old ordinance, the current meet and confer ordinance talks about a petition only, and this, Councilmember Villanueva, is where you get into the 50% that you talked about earlier. Under the current ordinance, 50% of the employees in the represented group have to sign the petition plus one. And then that is the way by which they elect their representation. They sign the petition if they want this group to represent them for purposes of meet and confer. The new proposed ordinance bifurcates that process, and somebody signs a petition not because they necessarily want this particular group, but because they want an election. And 30% of the employees in the represented group have to say, I want an election, by signing a petition. Once that happens, that triggers the election process. The petition section is Section 372, and it requires the employee to identify the group to which they belong, to put their name down, and to sign it. It gives a time frame for which those signatures are good of 90 days, and it gives a time frame of when those petitions need to be submitted for the annual potential of an election before meet and confer occurs, and gives staff enough time to confirm the signatures and get everything in place to engage in meet and confer. The election process is in Section 373, and the election process is significantly different in what we currently do under the current ordinance. When a group signs the petition and an election is called, the city manager puts up a notice. Anybody else, any other competing organization, can go get at those same 30% signatures and get on the ballot. Then the ballot has also a selection of none. So if employees don't want association representation, they can select none. Then the election occurs. And this is where we get into another area where we need some better direction from you. In subsection D and subsection E, it talks about the vote of the majority of votes cast in an election. That language was agreed to on the 18th, but again, there was give and take there. There was a lot of discussion by council, but not clear direction on what you wanted that to say. There was some concern that the majority of votes cast in an election would reduce the number of affirmative action by the employee to get a representative group, and that's very true. When you have a petition that's signed by 30%, and then you have 10 people show up at an election, and 6 of them vote to have the representation, it represents then the entire group, not just those people who voted, and there's no really ability to opt out other than dues. So there was some concern that raised by council, and so we've brought forward tonight 3 different options based on your input. Option number 1 is to leave it the same, the majority of votes cast in an election. Option number 2 is the majority of employees in the eligible employee group. Now that's consistent with what we currently do, which is 50% of the employees in the group have to sign their name saying, I want this employee organization to represent me, plus 1. So 50% plus 1. Another option that we heard from Councilmember Woodard was the majority of votes cast in an election during which at least 66% of the eligible employee group participated. So if 66% of the employee group comes out and votes, the majority then rules the day. And I think it was likened to having a quorum was the conversation from council. So what we would like to do is have direction from you if which of those 3 options you would like to see in an ordinance, or if there was something else that you would rather see come back in an ordinance.
What's common practice there, Misty?
It's really kind of split. There isn't really a best practices. Some meet and confer ordinances are still in the 50% plus 1, and I have not specifically looked. 30% to trigger an election is pretty common, but I did not go back and look and see how many votes were required.
I think, there's a tremendous amount of apathy in any organization. And we certainly see it at election time. What I would suggest is that we drop that 66% down to 50.
So the majority of votes cast in an election during which at least 50% of the eligible employee group participated?
Yes.
Yeah, that'd be fine with me.
I would be for option A. I think both based on the last conversation, I understand, you don't want to base this type of decision on 5 votes, but I don't think that's the case especially with police and fire. And it just keeps it very simple, straightforward, fair.
Well, I like option 2.
And this is why there's 3 options this evening for you. Well, if we could at least get kind of the best of 2, then we could come back and you guys could maybe take an up or down vote on whichever one. But
I think I'd like to hear what other organizations are doing, what the
kind of a survey of what
majority practice
if they have
would be.
elections.
Yes.
Sure, we can absolutely bring that back to you.
I kind of agree with Richard at 50%, but I'd like to see 50% plus 1, Richard.
Yeah, there you go.
We've got a lot of different direction there.
I did. I think what we'll do is we'll bring back a survey of those municipalities in the valley that actually have an election component to their meet confer ordinance. What amount of votes do they require? And hopefully it's not as diverse as you, and you can get some better insight into what maybe would be the course of action you want to take.
Okay.
And also, I just wanted to point out in subsection E, because of the uncertainty of the language, we are recommending the change to a sufficient number of votes, just so we don't have to change it twice every time you guys might want to discuss it. So if that's okay, we'll keep that small change in and bring back options in paragraph D. Continuing on with the election process, subsections F and G and H, again, just talk about the election process and how often. Specifically H, you have to be a certified employee organization for at least 12 months before anybody can decertify you. On F and G, I wanted to bring those to your attention because we are making a recommended change. F requires that an election dispute shall be resolved pursuant to 3-77D, and that is the mediation component. And as the legal department, as we were reviewing all the input that we got and the direction from council, one thing that struck us was that to resolve an election dispute by mediation takes a long time. We have to pick a mediator and go through it, and by that time, then the time to actually have meet and confer is probably going to be gone. The other thing is in G, the city manager may refer to the administration of the election to the city clerk. And what we're recommending then is to merge those two and to have elections administered by the city clerk and any disputes resolved by the city clerk. And we're making that recommendation because the city clerk is in charge of elections. She is familiar with elections. The city clerk is an appointed official that has no dog in the fight with regard to management and management relations with employees. And it's a quick and immediate resolution of the issue. So that is a recommendation that we're making, and Councilman Broughton has comments.
Have you talked to the city clerk's office about this? Are they?
This was a discussion that we actually had either yesterday or today.
Misty, I personally, these are outside associations. Okay? City has nothing to do with.
When you say, I'm sorry, outside associations?
These are outside associations. These are associations that they have put together, represent their co-workers. Okay? I don't think the city, and especially the city clerk's office, has to be involved in this.
Well, the city, under the ordinance, if we have elections, somebody has to do the election, and right now that's the city manager's job. And if the city manager does the election in a way that is dissatisfactory to an association, now we have an election dispute, and who's going to resolve that dispute? There's a lot of options. We could bring it back to council, but then it creates a political issue, which you have expressed you didn't want.
Right.
We could have it go to an outside judge, but we can still do that. It could be resolved by mediation if you want it to be, but that is going to take a little time and might disrupt the timing of meet and confer. And it might be an issue that, frankly, the city clerk could resolve.
But the meet and confer is not the issue. It's the elections.
Correct. That's why we're
All right.
recommending
So it's got nothing to do with delay of a meet and confer.
Well, if they aren't elected, then they can't
Well, they wouldn't
participate.
even be at the table, would they?
Correct, and that's the issue. I mean, if somebody goes through an election to
Okay.
be able
And the
to
elections
participate,
happen when?
in August,
Okay. And the meet and confer is in December?
October 1st, with the
Okay.
ordinance.
Well,
moves
they've
it
got
up.
time to work it out.
Sometime, that's correct.
Okay. And it would be to their benefit to work it out internally, wouldn't it?
Maybe. There's a lot of different scenarios. What we're looking for is just a crisper resolution process that everybody knows in advance so that it can be done quickly.
Yeah, I
And
personally
whatever-
feel that we should have somebody from the outside, not the city.
Mayor and council, if I just may make a point, the associations are getting grandfathered in. And so typically the election that will, under the current state of the ordinance, so an election that would arise would be a decertification as opposed to a certification initially. So that would be candidly an unfortunate circumstance where you would have qualified individuals who would want to decertify the existing organization. And while there is, I think, a perception of its associations, they are our employees. So they are part of us. So to the extent that we can offer that to the employees, I think that's something that the council needs to just consider.
Well, at the same time, for the employer, how many places does the employer get to certify the election, or certification or decertification of a union. That just doesn't
Councilmember-
ring, and I realize that there are employees, and they are, but they're also the union. It just
And that is why
doesn't
we
ring
recommended
true
it be
there.
the city clerk, because the city clerk is not the city manager. The city manager has control and is the supervisor ultimately of all employees. And they don't really have a dog in the fight. That's why we recommended their use. But
The city clerk does report and is appointed by the council,
Right.
which could be political.
That's true, and as city manager is also, and as is the city
Yes.
attorney. So
But
there really
if I
isn't any
just
good.
missed, if I may, to that point, though, again, you're correct, but the clerk reports to you, and it's your ordinance. So to the extent that you can provide direction to me, the city manager, to the clerk, you would have that ability here. And again, that's why
That's what I
we looked
want.
at it, setting it up
I
this-
want to avoid is giving direction to the city clerk on how to run these elections.
But to the extent that you give direction to the city clerk, it would have to be a majority of you. You'd have to do it at a public meeting, so all of the parties would know exactly what you're doing. As opposed to a city manager who, and I talk about that in the position, as opposed to an individual, a city manager who would be handling this election, who has a dog in the fight, so to speak.
But
Another-
ultimately, the city council, if either side can't dispute something, settle it, or even they go to mediator, the council is the one who make the final decision, won't it?
If it goes through the conflict resolution process in 77D, it would ultimately come before council. The difficulty with that is really the timing, and I think Michael's point of if there's a decertification election and we can't get that done before meet and confer starts, you're going to have an association where a vast majority of employees don't want them negotiating, and yet they will. Another option, though, is to use the retired sitting judge, or excuse me, the retired Superior Court judge in 318 that you've already given direction to include. So that's another option. It just gets a legal opinion. It's quick. It's final. It's outside, as Councilmember Alton noted. So there is, it's just, was the election done pursuant to appropriate protocol or not? So that's another option. So we can change that if I have consensus on that item.
Yeah.
We don't anticipate this. I mean, this would be a rarity. We don't anticipate it.
Right. Yeah.
So change it to 318?
Yeah, I'm good with that.
Now we're getting to the guts, meeting and conferring. Subsection A outlines the parameters of meet and confer. The current ordinance simply says wages, hours, benefits, and working conditions. This section ferrets that out a little bit more, gives greater detail to the parties, and also includes those things that are not included in meet and confer. This was agreed to by the parties, and there's no subsequent recommended changes. So unless you have a question, I'm going to move forward.
There's no changes in this? 1 and 2?
Not from the proposed changes that you guys looked at on the 26th, that's correct. Initiating the meet and confer process is very similar to the current practice in that proposals are submitted. There is a date change to October 1st, but that was agreed to by all the parties. That gives greater opportunity. With Christmas, what we've traditionally been running up against is with Christmas holidays, it's very difficult to schedule meetings and get facts and figures necessary to inform council. So it's really an attempt to be better at getting the necessary information to make good decisions. The representatives of the city manager and the designated employee will begin meeting and conferring at mutual convenient times. Under the current ordinance, it requires every single week, and sometimes that's not beneficial because we have to go figure out how much a certain recommended change or proposal is going to cost, and that sometimes takes some time. So this primarily keeps the same general process, expands the time frame. Subsection C outlines the 3 representatives. You guys did give feedback that you liked that, 3 representatives from each side, but yet allows flexibility so that either side can add, by agreement of the parties, more people if the topic requires it. It also does something very important, which is absent in the current ordinance. It defines good faith. That has come up a number of times. You're not acting in good faith. Well, good faith is defined here. It's basically the legal definition of good faith, and it was agreed to by the parties. So that you could kind of conceptualize what this ordinance does as far as meeting, conferring, and conflict resolution, we did put this little schematic together. The proposal is submitted by the associations, then the meetings are scheduled and held. If there is an agreement, it goes to a memorandum of understanding under the proposal. If it is not, it goes to mediation. If mediation results in an agreement, again, a memorandum of understanding is created. If it does not, it then goes to council. You will then provide direction and an MOU will result. So that just that's how the process is set up under the current ordinance. Now, that was agreed to on the 18th. The Fire Association requested changes to that, and we're going to talk about those in just a few minutes, but I wanted to make sure that you understood under the proposal as it was written on the 18th, this is how it would work. Did you have anything, Councilmember Alton?
Does this ordinance, it's an ordinance that we're looking at, correct? Yes. Does this ordinance, it gets codified?
Yes.
And so MOUs have never been historically codified.
We have never had memorandums of understanding. The current ordinance requires what's called a joint recommendation of action, and it was simply received by council by motion. Although the ordinance allowed council to amend it, change it, or do whatever, there was no requirement for it, and there were some significant issues that we have in the legal department that sometimes that can conflict with Chapter 2. You know, we have a manager-council form of government, and the day-to-day operations are delegated to the city manager, and if you have the city council getting into what those day-to-day operations are, that sometimes muddles the water, which is why when we structured it, if there's agreement under the current ordinance, it does not come to you because there's agreement. And so what do you need to get into it for? However, we do need somebody to resolve disputes when management and the associations can't get along. So if there can't be resolution through mediation, ultimately it does fall at your feet. But the way it was designed in the proposal that was agreed to on the 18th, it was to basically try to keep you guys out of day-to-day operations of city management.
Yeah, and that's the last thing we want to do is just to manage the city. We'll set policy.
Right, exactly. And this is the establishment of policy as it relates to
It's my understanding through people that I've spoken with that this last meet and confer that was conducted by the city manager went extremely well compared to the previous year or years. Okay?
I would agree.
And I think it was because it was in-house. We didn't have an outside attorney.
I agree.
All right. We had our own HR people working it. And I think that you got the message from the council is that we need to get along with one another. And we need to start with our employee groups. And I think that it went extremely well. Yes, there's no money and nobody got any raises. But we are looking at the safety and protection of both the police and the fire and make sure they have adequate equipment. But what I wanted to say is I'm very proud of our city this last meet and confer, and may it continue to operate that way without adversarial relationships. Thank you.
So moving on to some of the guts of that, the memorandum of understanding under the proposed ordinance that was agreed to on the 18th requires that all areas in agreement go into a memorandum of understanding. Areas in dispute go through that process that I just outlined in the diagram. That the the memorandum of understanding applies to the fiscal year unless the parties agree that it goes beyond the fiscal year. And it's important to understand that this is in subsection B where it says that a memorandum of understanding cannot be modified by a city manager without written agreement from the authorized representative employee association. This is a significant expansion of the rights under meet and confer from the current ordinance. What this says is that if a memorandum of understanding agreed to by the city manager's office and the association, if that provides a benefit to the employee, that benefit cannot be reduced or diminished without going back to the association first and trying to resolve that issue. The current ordinance has a provision called a mid-year budget change, which would require that kind of thing to occur, but only if the city manager declared it. Well, if they don't declare a mid-year budget change, then you don't have to go back. Another competing provision is typically referred to as the fiscal crisis provision. Same problem. If the city manager doesn't declare a fiscal crisis, you don't have to go back. This requires a city manager to go back if any of the items that were agreed to in a memorandum of understanding are intended to be diminished or reduced in any way. Conversely, the city manager does not have to go back and say, I'm going to give you greater benefit. He can just give it. But if it's in a memorandum of understanding, he can't reduce it. So that's a very important distinction.
But what
that you need to
happens if
understand.
we have a crisis within the city?
The city manager can go back to the association. If they can't agree, it goes through that same conflict resolution process that's outlined, goes to mediation. If they still can't agree, it comes back to the city council. And one important thing that you need to realize is that you control the purse strings. So no matter what, if you don't like it, you control the budget, and you cannot abdicate that responsibility. So this is all subject to budget approval by city council no matter what.
Okay.
But it's an important distinction that I wanted to make sure that you knew about. And subsection C just talks about the conflict resolution process. Then that brings us to items and disputes. So going back in your head, if you can go back to that diagram. If you can't agree, mediation doesn't work, what happens? It goes to the city council. Subsection B, and I did not take personal offense at Councilmember Williams' comment about the essay, but subsection B is simply an attempt to define the parameters for mediation, and it's important to do that because a mediator may not be the same mediator from year to year if it happens more than once, and what we want to do is consistent. And so what subsection B is trying to do is require both parties to put into writing what their issue is. That requires them to put some forethought into it and support it, and it prevents sides from deviating and changing why they're objecting to something. It makes them put it in writing, and that's why it's in there. The reason why it's 1,000 words is because that's roughly 3 pages at 12-point font. And having been through law school and having been through brief writing, if you can squeeze in a couple extra words by changing the font size and that inures to your benefit, of course you're going to do it. We don't want that. So that's why it's 1,000 words, just to make sure that people are not trying to cheat. So that's really what that is. And because you guys wanted to use a mutually agreed upon mediator, we are recommending a small change in subsection B to add 15 days of selection. Within 15 days of selecting the mediator is when you'd have to have this position statement presented to the mediator. And that is going to help resolve issues, because if everybody understands the solidified reason for the disagreement, it'll come to an end quicker. So that's really the purpose, but by no means is that required if you want to take it out. And I will tell you that the Fire Association, subsequent to our meeting on the 18th, has asked that this be taken out. I'm sure Ms. Moore can fill you in as to why that is, but that's really the entire purpose is just simply to set parameters, and those parameters can be whatever you want them to be, including free willy, whatever the mediator wants.
Well, my only question, and going back to this, and if I understand the position statement, so I apologize if there was any offense to that, but at what point, going through this, and you haven't gone through it, so I don't want to jump ahead, but at what point do all the parties sit down and have that discussion with the mediator?
That would be up to the mediator to decide, and we would expect that, depending on what the issues are, if the issues are something that are very cut and dry, there's not really an opportunity to come to an agreement, the mediator can just issue a written recommendation. My experience with the American Arbitrators Association and the mediators that they use, they would have a sit-down. They get the position statements, they familiarize themselves with the issues, they sit down. They usually split the parties up and go back and forth between rooms.
And that's my only concern with putting a ceiling or putting minimum words, or I mean that might not give them the capacity in the ordinance that says to not include any attachments, any exhibits. It might not provide them the capacity to explain the whole story, their entire point of view.
Right.
So in terms of moving this forward, I'd like to see at some point where the parties just sit down and have a discussion, and then I would be okay with the position statement.
It does indicate that exhibits and things, again, that's an attempt to not let somebody go far afield. But if the mediator, if you look down in the fourth line, agreed to by the parties, so if the parties agree to have bigger, better position statements or attachments, or when requested by the mediator. So if the mediator wants more information, they can give it. This is just a starting place. But we can absolutely come back and specifically say that you want the mediator to have at least one sit-down meeting, and that's what I'm hearing, Councilmember Williams.
Or a hearing.
Well, mediation's a settlement conference, so it's going to be a meeting, not really a hearing. But if you want them to meet, we can absolutely include that as a minimum requirement. The mediator can work with the parties and go above and beyond that. But we do think it's important to kind of set some parameters from your perspective.
Okay. Go for it.
So go ahead and add at least one meeting. And then, as we discussed earlier, if the mediation is successful, it never comes back to you. If it's not successful, it comes back to the City Council. And subsection D is the change, Councilmember Alton, that was specifically requested and directed by Council on the 26th, was to pick a mediator from the list of mediators maintained by the American Arbitration Association. Okay. There were some changes that were requested on the 25th by the Fire Association. They had included it in subsection 377 as a whole new section, subsection E. And I want to break down the components. If you want to hear from Julie, I just will draw your attention to the time. I know you have another item. It's 5:21, and I know you guys have another meeting this evening, so just to draw that to your attention. The first item in the paragraph that they want is on or before March 1st, all areas of agreement, areas in dispute, and still under consideration shall be submitted to the mayor and council for their consideration. That's completely contradictory to the mediation provision that we just went over that was agreed to, so I'm not sure why they would want to have this language. It would conflict with the mediation provision. It also is significantly similar to the current ordinance because there's still under consideration under the current ordinance. Either it's agreed or it's in dispute. There's no in between. So we would recommend not adding this change because it undoes what everybody has already agreed to do. The next section is the mayor and council may accept, reject, modify, recommend areas of agreement within the proposed memorandum of understanding. The mayor and council may also take whatever actions they feel appropriate with regard to those areas in dispute. That goes back to at what point in time is council looking at a memorandum of understanding and potentially interfering with the day-to-day operations of city manager. And for that reason, we would recommend not including this kind of language. But again, it is your ordinance, and I'm sure Ms. Moore can explain to you why she wants those items in. The next section is final action by the mayor and council shall constitute the memorandum of understanding for the fiscal year or other designated period. I don't know if you can recall, but a few moments ago we talked about how long does the memorandum of understanding last. It's for the fiscal year unless the parties agree. So restating it here, we don't like to do that because if you change it once, you have to make sure you change it in every place. Otherwise, there's creates vagueness. Also, the memorandum of understanding, if it does go to the mayor and council, we just want to be clear that the agreement isn't between council and an employee. It's between the city manager's office and the employee. Otherwise, you start getting into the day-to-day operations and interference by council, which in Chapter 2 you said you didn't want to do. So, and the final thing is that it's not the final one. I take that back. The memorandum of understanding will be in article format. That was specifically negotiated not to be in the ordinance during the 18th. I'm not sure why it's back in. What was agreed by the parties was that we'd wait for the first meet and confer to figure out what the best format is. And then finally, and this is probably the most significant thing, the previous agreed upon and council approved joint recommendations of action enacted under the surprise meet and confer ordinance 0102 shall constitute the first memorandum of understanding. There's all sorts of reasons that this is problematic. If you'd like to know what those are, we can discuss them here, but I would recommend going into an executive session because there are issues greater than you may want to discuss in a public meeting.
Didn't we, 2 weeks ago, didn't we say something to the effect that let's square away all the JRAs?
In the first meet and confer, but there was not. I wasn't sure that there was consensus that was the direction of council. I know that's what you had said, Councilmember Alton, but I wasn't sure.
I did.
That is the request of the management, I know, is to do it in the first meet and confer.
Right, but I don't know if it needs to be solidified into the first MOU. Wouldn't the first MOU be like next time?
It'll be this October.
This October?
Which is why I think, and Councilmember Hall's shaking his head because I think the two of you were the ones that were.
Yeah, but at the same time, there has been no history codified as to the negotiations with the different associations.
They're typically codified, not really codified, but they're typically commemorated in the employee policy manual. So, for example, hazmat pay. Hazmat pay is paid, I can't remember exactly, I think it's $1.05 an hour. That's in this employee policy manual. That was a result of meet and confer.
And that was a JRA?
Yes, it was.
Okay.
So there was an effort to...
How many JRAs have not been resolved?
According to former Human Resource Director Bowers, they all were. However, I will tell you that I've recently read them, and there's a couple of provisions that are not benefit-related, though. They're not whether you get PTO or whether you get certain compensation. But there are a couple of provisions that we're going to want to put in a future memorandum of understanding, but I really think the best time to do that would be in this coming fall. So if I don't hear any voice from you that you want any of these back in or into the proposed ordinance, I'll move on.
I would like to, you mentioned that there's another side to this. I would like to hear them. I'd like to hear why maybe we shouldn't. Or should.
If you want to hear that now, or if you wanted, I know you guys wanted to have that come back, the
Yeah,
mayor
actually,
direction.
I would too. I think that's why I requested that we have a dated response, starting with the 18th in the council meeting, and this evening, then a discussion with the associations, and then an additional workshop to understand what the process has been to...
Yeah, that was my understanding.
Okay.
So is that agreeable to you, Councilmember? Okay. The next section is prohibited activity, and this again was another subject of great discussion at the 26th meeting. The content of it was not so prohibited, but I will say that in the decertification section, back in the election section, there was a subsection I that we haven't gone over yet. And the reason we haven't is because that was if anybody in the employee organization promotes or instigates, encourages, supports, threatens, or participates in a strike, slowdown, that kind of thing, that the employee association would automatically be decertified. Well, when we were doing this for final review in the legal department, we noticed that that same language was contained here in section 3-76, and it makes more sense to have the consequences of bad conduct in the same section as the bad conduct is defined. So we're recommending that to the extent that there's any decertification consequence, that be included here and not in the decertification section. So we've moved it in this recommendation. And so that language about slowdowns and strikes is contained in subsection B. Another thing that I want to bring to your attention, though, is subsection C. And this is very new, and this is us trying to be proactive. Subsection C declares the best interest of the city of Surprise is that information, documents, anything prepared during meet and confer, maintain confidentiality during meet and confer. That is so that the public and the press do not interfere with the negotiations immediately after meet and confer is over. However, they would all be subject to public disclosure. This would give us a good defense, for example, in a public records request, to deny that request pending the completion of meet and confer, and then release those documents. So I wanted to draw that to your attention because it is a significant change of the current ordinance. And coming back to that change that I just commented on, that decertification provision, we're recommending that be put in as subsection D of 3-76, prohibited activity. And it reads much like it did when it was in subsection I of the decertification. Any employee organization that violates this section, now this expands it beyond just strikes. So if you basically, if as an employee organization, if you violate any of the prohibited activity, you're going to get decertified for 2 years, which is the direction of council. But we added something because, you know, there's a yin and a yang, and there's city management, and we think that it's appropriate that city management have a similar consequence. And so what we're recommending, and this is new, it has not been run past the associations because it was new as of yesterday or today, violations of this section by the city manager or on behalf of the city manager shall be referred to city council because you're his boss or her boss. And that violations under the section shall be determined in accordance with 3-18. Again, that's that outside legal opinion by a judge. And so what we're saying is that we want somebody outside the organization to investigate whether there was a violation. If there was a finding of a violation, it automatically decertifies the employee organization. And if it's a city manager, it goes to you so that you can discipline the city manager as you deem appropriate.
Mitzi, is it not state law that public safety employees cannot strike? Is that Arizona law?
The statute itself actually does not say they can't strike. It says they cannot strike to force an agreement. They could strike for other reasons, but they can't strike to force an agreement. And if they do, then the agreement is void. So the only consequence in state law for striking to force or coerce an employer to enter into an agreement like this would be that the agreement's voided. There's no other consequence. There is also a section of state law, however, that says that employees can picket. And I'm not sure about you, but there's not a big difference to me between picketing and striking. And I will also tell you that we have policy, employee policies, that if somebody did not come to work, that there are consequences for that because they're absent without leave. So going back to the discussion that you guys had with, do you punish the organization or do you punish the employee? Well, if they violate policy, they will be appropriately dealt with per policy. This really talks about meet and confer in the organizations, which is why we make the recommendations that we do. And before, I want to bring this attention to you. This is the language that the Fire Association had wanted in here, that the employee organization pledges to maintain unimpaired service, and that should the employee organization breach the obligations, that they'll tell the employees basically to stop doing it, or they'll take responsibility. But I think, as one of the council members pointed out, there's nothing in here about what that means to take responsibility. So our recommendation is decertification if an outside fact finder determines they violated the prohibited activity section. Same thing with the city manager. If they do it, doesn't matter. There's going to be consequences. It's to put teeth.
And I was pretty vocal on this last time, and I understand the intent. My concern is, how do you get to that point? And it doesn't completely articulate it, other than the fact that we've noted in the ordinance what is prohibited activity. But what constitutes the organization? Is that 2 employees doing this? And then the entire association gets the wrath of 2 employees? That's my concern, because that's not in this. That's not stated anywhere. So, and your lawyer, you can argue that point. You can definitely argue that point based on this wording. So that's my concern here, and that's why I would defer to some of the other wording, or maybe a molding of the 2, and again go back to meet with the associations and discuss that. If I'm a teacher, and not to compare apples to oranges, but I wouldn't want that to some other person to affect me. Sure. And my affiliation with anything. And we did hear those comments that you made, Councilmember Williams, and we did make a somewhat nuanced change in that any employee organization that violates this section, or whose members on behalf of such organization violate the section. So employees can't be doing it for their own accord, but rather on behalf of the organization as a whole. And by adding that this violations will be determined by an outside basic fact finder, they have to come to the conclusion that the employees did it on behalf of the organization, because the organization is not capable of acting. It can only act through its members. So there would have to be a finding that the members did it on behalf of the organization as opposed to on behalf of themselves. So they would have to, are you saying the association would have to give their blessing to this?
Well, it depends on the circumstances, but one circumstance could be that, for example, the fact finder could determine that the organization at a meeting told its members to do it, encouraged its members to do it.
In that case, that would be fitting of this.
Right.
In that situation, I don't know. I think there's a lot of.
I think it says it, John, in J, in paragraph J. There's a lot of words.
Just a lot of words.
It's very wordy. But I think that's exactly, in other words, if a person is doing a prohibitive activity, they have to let the organization know they're doing the prohibitive activity.
then the organization either can sign on to it or disavow it.
Well, and
Right?
that's a good point, because I and J are not currently in the ordinance. So if you want J in there, you need to tell me, and we can absolutely add that. So if you want a mechanism by which management has to put the association on notice, you are violating, you are conducting prohibited activity, and give a certain time frame for the organization to correct that, then we can absolutely add that to the ordinance.
I would ask that, if this is how we're moving forward, I would ask that that be put in. That's a good point. I just want something in there that will articulate that, because at the end of the day, it's public safety can't strike. You can't. You can't. They can't. So it almost seems redundant, and it almost seems like that person needs to be disciplined, that individual. And I don't think the entire association should be
And just to be clear
disciplined.
again, employees are disciplined under the Employee Policy Manual through authority given to the city manager by council in Chapter 3. And so if an employee uses public resources, doesn't show up for work when they're supposed to, anything like that, they will be handled appropriately pursuant to city policy. This ordinance really is talking about the association, and if the association advocates certain kinds of behavior, what is the consequences of that? And so what I'm understanding, and correct me if I'm wrong, is that we're going to add language similar to that which is included in subsection J of the Fire Association's recommendation, specifically giving the opportunity of the association to cure any prohibited activity that comes to the attention of management. And I will also suggest that we maybe add a rule of evidence, kind of, that the violations have to be proven by a preponderance of the evidence. That is more likely than not, so that we get away from or reduce the risk that a lone employee's actions would result in a decertification on the behalf of the association. So we will add those and bring those back to you at a later time, unless I hear anything else. And just really quickly, we're almost done. This is the last section, breach of an MOU. It has that same exact kind of provision, an opportunity to cure. If it's not cured, goes through the mediation process and ultimately back to you. And that's it.
Question. Back on 376, back where we just were, prohibited activity.
Yes,
One
sir.
of the things that concerns me is sick out. Well, two questions. Who determines whether or not a strike is in action or in force? That's one question. And when we're dealing with public safety employees, these are the people that go into not always the best places to go to. Example, some fellow has a heart attack. We have a group of public safety there. Maybe a couple of police officers respond first, then the fire gets there, or vice versa. And I know you're not going to you can't catch a heart attack, but the guy's wife has the flu or some other contagious disease. So all of a sudden you've got maybe 10 people that have been exposed to this, and it's quite possible that they could all be from one station. Like when they come to my place, you could lose a whole crew, and that might spread further through a department because hey, they do get together, I'm sure, on and off.
And then
So that's a concern. Who determines that it's a strike? And sick outs, I mean, we could have police, fire, and who knows. That's a concern.
The recommendation, and I believe the consensus that we have received, or the direction that we've received, those determinations would be made by either a retired judge of the Superior Court or the Appellate Court, who can establish that violation by a preponderance of the evidence after the opportunity to cure has been provided to the association. So if the city manager believes that there is a sick out or a slowdown, they would notify the association. The association would have the opportunity to cure it if that's what it is. If the city manager is not satisfied, then the city manager would refer that to the fact finder, which is the retired superior or appellate court judge, who would determine the fact of it. and they would have to do that by preponderance of the evidence, and then and only then would any consequence come to the association. So if it's a legitimate mass illness of numerous employees, I suspect that that is what the retired judge would come to the conclusion. And one of the factors would be, when does that happen in relation to meet and confer? So there's a lot of information that's going to be available to the fact finder, and they'll have to make that determination, and that's why we are recommending it be an outside judge.
I would just hate to see a union get banned for 2 years because of true illness. And speaking of 2 years, I'm not comfortable with 2 years. I'm much more comfortable, if there's going to be any, that it would be no more than 1 year. But I'm not real comfortable with 2 at all. That's they get banned, and violations of this section by the city manager or on behalf of the city manager. I mean, he may get fired, he may get slapped on the wrist, he may get a week or 2 off work, without pay. There's some disparity, is what I'm saying, that I'd like to see corrected.
We can discuss that item again. I believe it was discussed quite a bit the last time, and perhaps you can help us recollect how that discussion evolved.
Absolutely will, sir.
Okay.
That's it.
Does that complete your presentation? Thank you very much. We'll move to the next item, please.
Yes, Mayor. Item 2, presentation and discussion regarding the fiscal year 2012 budget, including capital improvement plan and potential interfund loan refinancing.
Good evening, Mayor, members of council. What we want to do tonight is follow up the conversation we had with the council at the budget workshop relative to a proposal to refund an interfund loan relative to a new state law surrounding the collection of impact fees. So we want to talk about that, and then conversely, or related to that, we want to explain to council how, if that proposal were to move forward, it would affect select CIP funds, and continue that discussion about this whole topic. The intention is to bring back to you a week from this evening more details about the terms of the refinancing, but tonight we want to focus on why we're doing it and then what the opportunities would be created in doing so, given the timeline that we're on, which is June 1st. So let's start with the general government impact fee options that we talked about at the retreat. We talked about really 3 options, and we're going to be focusing on the refinancing. But just for review, we always have the option to do nothing, which in our interpretation would mean we'd have to write off that interfund loan because the fee would no longer be allowable. We could formalize the terms of the interfund loan under the premise that if we were to believe that the interfund loan meets the legal definition of debt in the new law, that would be consistent. But again, staff doesn't share that opinion. So that leaves us with option C that's on this slide, which is talking about refinancing the loans by June 1st because we believe the interfund loan does not meet the definition of debt in the new law. In other words, there's not a 2-party transaction. And then, just as importantly, it best protects the city's ability to continue to collect the general government impact fee. Nothing's an absolute protection, but we believe that course of action is a better protection against any of the other options that we've outlined on the slide. So the objectives of the refinancing are really threefold. One's to satisfy the requirements of the new state impact fee law, which prohibits the collection of the general government impact fee unless prior to June 1st, 2011, the fee has been pledged to repay outstanding debt. We've talked all along throughout this whole situation, even before the new law, but with the Red Oak report, we talked about protecting the integrity of the impact fee program and we've also talked about growth paying for growth. So we believe that the recommendation to do the external refinancing is consistent with the sort of the policy and the outcomes that we've been talking about for about the last 6 or 8 months as we've addressed this entire issue. Some of the components of the refinancing that we introduced at the retreat, we talked about it being direct placement with the bank using a trust agreement authorized by the City Council, and that has as much to do with the time frame or the time crunch that we're under, which is basically less than 30 days from the time we were allowed to address this issue. The repayment source ultimately would be the excise taxes in the operating budget, and that's where we had the conversation about the two, or what we now know to be the $3+ million worth of capacity that's been created. So that capacity would be, in the near term, how we could issue the debt. We talked about the terms still being to be determined, and just a progress update in terms of what staff and some of our financial advisors and our bond counsel, we've been working diligently on this the entire last week and the first 2 days of this week trying to pull this deal together. So we've had initial meetings with prospective banks. We've exchanged a ton of financial information in terms of them trying to understand where we've been the last couple, 3 years, where we think we're going the next 3 to 5 years. We've talked about how we project revenues, what our expense trends have been, those kinds of things. And so they're basically in the process now of doing a credit evaluation of us, as you'd expect any lender to do in this type of a situation. So as I alluded to earlier, at this time we fully expect to be able to come back to council next week with the terms and have a real detailed discussion about that a week from this evening. But in the meantime, we want to talk about how the money, under the premise that the money is going to come into the organization, how it's going to flow through the organization, and most importantly, make sure council understands where the money will sit in the organization and the opportunities that that will present. So from a high level, we just want to outline here what we call the flow of funds. So $40 million will come in to the general government impact fee fund under the auspice of that we're refinancing an interfund loan payable that currently exists in that fund. From there, the money will leave the general government impact fee fund, and it'll really go 2 places. Most of the money, about $36 million, will go to the general CIP fund. That's the fund that, in the initial construction of many of the growth-related projects, is where the funding came from to build the growth-related projects, i.e. City Hall. Councilmember Alton, question.
I have a question. We're actually refinancing debt, correct?
We're refinancing an interfund loan.
Right.
Correct.
It's a debt.
Correct.
And what I'm very concerned about is we take this money that we receive in proceeds and we don't pay off the debt. We use it for CIP things of the future. All right? We've already got a debt. When you refinance the debt goes away and it's placed someplace else, correct?
I'll let you finish before.
Having been a banker, I kind of think that's the case. Or you're saying we don't have to pay off the interfund loans inside of the city, but yet we can use that money for anything we want to?
Let me clarify. What we're saying is there are interfund loans, and I'm going to use this example to be real specific to try to get right to your question, but that the general government impact fee owes $40 million to 2 places. 36 it owes to the general CIP, and $4 million it owes to the general fund. So by refinancing the loan, the general government impact fee still has an obligation. It's just an obligation to a third party. It's not an obligation to either one of those 2 funds.
But yet we're realizing some disbursement of this debt. We already have the debt, okay? And so now we're going to get a disbursement on refinancing that debt. A debt is a debt, correct?
Correct.
All right. I mean, maybe I'm not just getting it, okay?
Well, what we're focused, I mean, your premise, a debt is a debt. I mean, the general government impact fee, rather than it owing $40 million to 2 funds that are of the city of Surprise,
right,
it's going to owe $40 million to a bank.
All right. So
So what has changed, which is where the rest of the presentation's going, what changes is the financial position of the two funds, and that's where the opportunity presents itself to the city council.
So
So
then
you're
what you're
essentially,
saying-
the other way you can think of it is from the perspective of the general CIP, you're selling its receivable is another way to look at that, and you're turning that into cash because the needs of the organization are more driven in the near term for cash than the future, which would be reflective of a receivable. So I guess it depends which fund you're looking at, how you would perceive this transaction.
See, I kind of pictured these funds as kind of like silos, right? And now they have a negative balance, right?
Yeah, if you're talking
Or
about
40
the general
million,
CIP.
$35 million negative.
Yeah, one just doesn't have
Right.
any money, but
Right.
it's not negative.
So wouldn't it be more diligent on our part is to replenish those negative balances to a positive balance?
The reason they became negative is under the premise that they didn't have the impact fee at the time they made the expenditure. So the only way ultimately that those deficit funds are going to get replaced, which in this case it's the general impact fee, is from future impact fees. It's not going to be from any money that's generated internal to the organization. That's why if we come back to the premise of growth paying for growth and the state law, and if you remember back to retreat, that's why this issue is coming forward to you, is that we believe if we don't execute an external refinancing, that we will lose our ability to collect the $40 million.
I understand that. I understand. What I have a hard time understanding is that we're not really paying anything off. Okay? Your suggestion down here on the bottom of the page is $36 million goes to general CIP fund, all right, which can be used for anything infrastructure-wise, correct?
That's correct.
Okay? So we are getting out of a situation where we had interfund loans. We're not paying those things off.
Well, again, you are satisfying the interfund loan part. The true fact that the general government impact fee owes two funds money is changing from it owing two funds to it owing a bank.
All right.
That's essentially
All right.
what you. So you
our
are
fund-
paying off the interfund loans. That's the point I need to make sure that we are paying off those interfund loans. That's the premise that we believe will satisfy the state law. That's why we're motivated to do that.
Okay.
So if we can move through the rest of the slides, you'll see the opportunity that presents the city. But we are, in fact, paying off both those loans. That's why the general CIP fund now has cash, is represented the fact that it's taking its receivable that it now has, it's getting paid off, and it's turning into cash for which the council can then allocate those resources.
Okay.
And that's really what we wanted to do in the second section, is talk about how the proposed refunding moves through a couple of the key CIP funds, so council's aware of what the financial condition of those funds will look like. So let's start with the general government impact fee fund. Right now, under the current economic climate, it's receiving a relatively nominal amount of impact fees. It already has an obligation from 2003 of, I'm just going to use the 2012 numbers to walk through the slide. It already has an obligation of $600,000 to pay off that debt service. Under the proposal, and this is the point we were just talking about, Councilmember Alton, it will now assume an external debt of $3 million that, for the sake of discussion, ultimately will get paid to the bank coming out of this fund. So the new interfund loan that will be generated every year in the general government impact fee fund is the difference between the two debt services and the relatively small amount of income that's going to be coming in. So in order to pay that, clearly it won't have the money. So the money will come from, until the impact fees pick up, will come from the operating budget. That's why you need and this is a confusing point, but it's also key to the strategy, is that the capacity in the operating fund in the near term will pay the debt, but ultimately the general government impact fee will pay the general fund back that debt once the impact fee amount catches back up to some sense of normality based on the debt schedule. So if you look through the rest of the columns of this slide, that scenario replicates itself in the near term until the economy comes back and we start seeing those impact fees get up to an amount that can support what would, under the proposal, be two pieces of debt. And until that point, we would use the $3 million that exists in the operating budget to make that debt service payment. Okay? But that, again, the reason we're doing that is to satisfy the new state law. Otherwise, we're convinced that our ability to collect impact fees in this fund would go away. And again, the $3 million is just an estimate and a placeholder until we actually get to the final terms of the proposed refinancing. So that's on a schedule what the general impact fee fund looks like. And then graphically, all we're trying to do is show you here until those impact fees come back, there'll be an interfund loan required every year to satisfy that obligation, again, until the impact fees come back. So that's the general impact fee fund. Now if we shift gears to the general capital fund, so this is where the $36 million is going to come into, and this is where we get into the opportunity for the council. So you can see at the top, the $36 million will come in this year, and I'm just going to walk down the rows. It's already getting about $1 million of construction sales tax, and again, I'll stay focused in the current year. A little bit of interest earnings there. We already have obligations for economic development incentives, and then part of the proposal would be this fund has $8.9 million of loans that it owes other places. So if the 36 were to come in and consistent with council direction based on what we've talked about before, we would pay off the interfund loans that this fund owes. That's what the $8.9 million represents. And then this fund has obligations to existing projects such as flood control projects and fire radios and those kinds of things. And we would, under the proposal, all of those projects would continue. So our share of those projects and grant funding are reflected in that project's net of third-party funding. So you come down in the first year, or 11, you're going to have a huge net activity number because you have the loan proceeds coming in. You compare that against the beginning fund balance, you're going to end the year about $24.5 million. Hold at that for the next couple of years for the sake of discussion, so that in 2014, from a projection standpoint, you basically have, at the end of the next 3 years, somewhere in the neighborhood of $22 million. That's the amount then that the council can program into expenses of its desire. Again, the money, at this point, you forget about why we did the refinance, because once the money comes into this fund, we can essentially use it for anything that the city council desires it to be used for. We can do new projects, we can do repair and replacement, we can do pavement management, and we'll talk about some other options in a slide. But I think it's important, we've got to bifurcate what happens to achieve the loan, and then what happens with the loan proceeds are really, they're related, but they're separate. And that's what this slide's intended to do. And Councilmember Alton, your point earlier is we do have to remember that we're in silos. So what's happening in the general CIP fund is different than what's happening in the general government impact fee fund. And, you know, one fund doesn't hold the other fund hostage in a sense that we just kind of need to hang on for growth to come back. We can do something about that in this fund, even though in the general impact fee fund, we do have to wait for growth to come back to do any more kinds of projects there. So visually, we're doing the same thing on the next slide. We're just showing you that over the next 3 years, from a projection standpoint, the council will have the ability to allocate resources of roughly $22 million based on future policy and priority decisions. And on the next slide, This isn't intended to be an all-inclusive list, but from gathering from the conversations, this is sort of some of the priorities that have seemed to be talked about the most. We could make a proposal to fully fund the reserve with some of that money. We could establish a strategic planning reserve for things like future economic development opportunities, land purchases, whatever that might be. We could increase the operating reserve if that was the desire of council. We could increase pavement management that I talked about earlier, or we could increase other asset repair and replacement, whether it's parks and rec equipment, stadium, information technology. So again, once that $22 million is up for future policy direction and discussion with the City Council, and we don't need to make that decision to adopt the budget, which is scheduled for its first reading on the 24th, we can just put that as a sort of a placeholder and have that discussion over the next year, over the next 2 years, quite honestly,
Scott,
that period of time.
Scott, I think we previously discussed this, and that I thought it was the opinion of the council is that we try to replenish the reserve as much as we can.
Yeah, and that's why
to get us in compliance with what we should have in there. Okay?
Right.
And then it was even stated maybe put the rest of the money in the reserve as a holding spot. What I really want to be very careful of is that we go out willy-nilly and do stuff without our due diligence and so forth. Okay?
And Councilmember Alton, that's what you just said is when we come back with the deal, that will be our recommendation is to do the math on the fully funding of the reserve, and my words, just park the rest in a strategic plan reserve and allow the council to have future discussions over the course of the summer about how that can get allocated.
That would have some impact on our bond rating, correct?
You're talking about replenishing the reserve?
Yes.
Absolutely. Solidifying that is a component of the bond ratings.
Right. Right.
And I think that's helpful feedback on this slide. So that, again, we've talked about the impact fee fund. We talked about the general CIP fund. We're going to shift gears for a minute just because transportation is such an issue. And the other thing I want to reemphasize is when we got to the retreat, because of what happened with the impact fee bill, some of these funds we wanted to talk about at the retreat, but we felt because of what was going on, it was better for us to go back, take a step back, and reassess where the numbers are going to go, and then talk about all the funds at once. And that's essentially what we're doing tonight. So the reason I'm saying that is the transportation fund isn't affected by the refunding, but what I wanted to emphasize here is, and we've talked about this several times, so I'll cut right to the chase, unless there is explicit direction by the council above and beyond the money that comes into the fund and the debt that already exists, we're only able to program about $1 million a year in street preservation for the next 3 years. And that was what was included in the city manager's budget. And so the point of emphasis here, again, unless there's direction from the council, that's all you would see when we bring back the tentative budget on the 24th is $1 million a year street preservation. And we do have $100,000 for a Peoria Road project, and then $600,000 for our share of an El Mirage Road project, and $2.4 million of Greenway Road, Litchfield to Bullard. So again, a relatively small transportation CIP program, unless council takes actions to bring more resources into this particular fund. Graphically, we're just showing you how over the next 3 to 5 years that the cash balance of that fund will change. And then another note.
Scott, don't we have time to do that between the time that you make the arrangements with the bank and we get funding on all you're talking about and when we finalize the budget? Don't we have some time to look at that?
Yes, we're coming back a week from tonight and going through all the policy decisions. You know, we talked about property taxes and water rates, and this would be one of the policy decisions. It would take an explicit action to modify the city manager's recommended budget to bring more resources into this fund or any other CIP fund. And so we'll talk about that. But we sort of have to deal with the refinancing first, because that tells you if there's resources there or not. So that's why they're all related. We've talked about the graph. The other point here, just to sort of emphasize the point of the impact of the new law, is we have how this fund primarily gets its money as a 1.5% dedicated sales tax. And as you remember, the impact fee law has some provisions that revenue has to be used to sort of buy down your transportation impact fee. So long term, we're still not quite sure what the implications are to this particular fund, and we just noted that with the bullet there at the bottom. The other fund we want to draw your attention to, just from an awareness standpoint, is the Fire and EMS Impact Fee Fund. And we went over the numbers before, but the abbreviated story here is from a cash inflow-outflow, we really built 2 stations ahead of the amount of money that we had. Each station roughly costs about $4 million. That's why at the end of 12 we're going to be about $8 million in the hole. The good news here is that the debt service is relatively small, so as the impact fees increase, the 8.1 will continually go down as long as the money that comes in is more than $100,000, because there are no future projects on the drawing board in the near future. So you can see that a little bit better on the next graph, that you can see the deficit, but that as impact fee and the economy turns up at some rate, that deficit will go away, and then we'll be in a position where this fund can actually spend money again. But until that happens, we're unable to really put more money into the fire infrastructure that's related to new growth. But essentially what this is telling us is that we really don't need to do that. We might need fire infrastructure for replacement and other things, but it's not related for new growth. So I wanted to make sure that was clear to the City Council. And then a similar statement can be made for the Parks and Rec impact fee. Is the impact fees are roughly $300,000 to $400,000. We have an obligation already outstanding. That's an $800,000 a year payment. So every year, the net delta on that's about $500,000. And that will, again, continue to go. The deficit will grow year after year, as you can see graphically, until that impact fee exceeds the amount of the debt service. So from the perspective of when we got in and looked at this fund, this is a revision from the city manager's recommended budget. In the city manager's recommended budget, there was an opportunity as we looked at the information we had at the time to do some funding and design of some preliminary work out at Surprise Farms. When we went back, and now that we see that the capacity that we're creating in the general fund is going to be used for refinancing the general government impact fee fund, there is no opportunity to do any projects in this particular fund because that capacity will need to go to that priority. So we've made a staff modification to our recommendation based on that issue, that capacity can only be used in one area and it cannot be used in this area. So that is a difference that I wanted to call to the City Council's attention. So if we kind of wrap this up by just looking at what loans look like at the end of last year, and you saw this slide at the retreat, we had $81.3 million worth of loans, and we talked about the 4 categories. As we move through the slides, we're still going to be able to solve the first 3 categories internally, where we're moving money, for example, from one impact fee fund to another. And then what'll be more clear as we go through a couple of the next slides is that 4th category, you're going to see that number go down significantly because of the refinancing. So that's on a category level. If you look at it on a by fund level, you get to the same $81.3 million, but you can see there's all puts and takes from, looks like 8 or 10 different funds. And that's, again, how we closed the books in 2010. And as we move to the next slide, you're going to see what that same data will look like under the proposed city manager's recommended budget. So you're basically going for, and based on the premise that we're going to do the refinancing. So you're going from basically having $81.3 million of internal or interfund loans down to $22.3 in internal fund loans, and they're really centered in 3 places. We talked about Fire Development Fund, we talked about Parks and Rec, and we've talked in the past about the Sewer Impact Fee Fund. So from a staff perspective, we feel like we've really taken a complicated issue through the recommendations in the budget and got it down to a manageable, explainable part. But we can now the only way this is going to get better is as growth returns. There's not much left for us to do. We can't go out and create capacity in the fire development fee or the Parks and Rec Fund fee because the revenue stream just isn't available to support any new resources or expenditures in those particular entities. So again, we're going from a pretty complicated matrix down to something that's more manageable and more consistent with the priorities of the organization. And so that's what it would look like at 11. And then I want to reemphasize before I turn it back to the Mayor and Council for comments is that we'll still have new annual interfund loans in the areas that I talked about during the presentation, but I want to bring those back so everybody understands that. The general government impact fee will really have the need for two loans. It's going to have the need for the existing 2003 at $400,000. And then in the bottom box, it's also going to have the existing $3 million to deal with the state impact fee law change. And as we talked about earlier, the Parks and Rec will still have a $500,000 loan, but that's going to be coming out of the wastewater operations fund. So once growth comes back, then we'll be able to address the information that was on this slide as well as the information that was on the previous slide. And we feel like all the other things and moving parts, we've addressed those through the refinancing as well as the prioritizations of putting together the city manager's recommended budget. So with that, Mr. Mayor, we wanted to continue to feed the information and the discussion on this idea of refinancing. We intend to come back next week with a firm proposal, and hopefully this will be viewed as background information. So if there's any questions or feedback that you can give us advance warning on, that will be helpful because we do foresee the 17th as a decision night in order to meet the June 1st deadline.
Yeah. Right. Thank you very much. Council, are there any questions, concerns, or observations?
No, good job, Scott, trying to get this thing somewhat simplified. I'm only somewhat confused. But I see on page 22, page 22 relates to page 11, correct?
Let me verify both of those. Take a break.
Oh, yeah.
Explain what you mean by relates.
Well, you got in fiscal year 2014, you end up with that green box, $22 million. And in your simplification page, you get $22.3 million.
There's no relationship between those two numbers. No.
Okay.
No.
All right. Because the one's cash and the other one is just journal entries.
Well, the green is cash.
Right.
The slide 22 that's up, or slide 22 that's up on the screen now, that's the amount that's owed to non-impact fee funds from impact fee funds for cases in which we fronted cash to pay for growth-related projects, i.e. 2 fire stations. So there's no relationship between those two. In fact, until you draw my attention to it, I didn't even see that those were so close. So I can understand why that's a little bit confusing.
Any other comments? Thank you very much, Scott. Good
Thank
job.
you, Mayor, members
Appreciate
of council.
it. Thanks. Okay, we'll move to item number 3, which I believe is called to the public, and we do have some speakers.
Yes, Mayor, 3, and the first is Brian Moore.
Honorable Mayor and members of Surprise City Council, thank you for the opportunity to address you. My name is Brian Moore. I currently serve as the board chairman of the Daisy Mountain Fire District. We provide fire protection, suppression, emergency medical services to the communities of Anthem, Desert Hills, and New River, as well as the North Phoenix area through the automatic mutual aid system. The 88 sworn firefighters in the Daisy Mountain Fire District are also members of the Northwest Valley Firefighters Association. Their autonomous chapter. I've been on the board for close to 10 years. Before I even got on the board, they had established a meet and confer process with a memorandum of understanding, MOU, essentially a contract for ongoing institutionalization of past practices and agreements. In fact, it was created because of continuous turnover amongst fire department management that existed during the early 90s. Their first MOU that I found that they created basically institutionalized all the previous agreements that they had come to, so that constituted the first one. They have a meet-confer process every year. Ultimately, the agreed-upon items come before our fire district board for approval. We're a 5-member publicly elected board with about a $12 million budget. So that agreement ultimately comes to us as the fire board for approval. Some of the things I've seen that have been discussed in this particular proposed ordinance, I seem to be somewhat far overreaching and causing unwarranted concerns and fears. I have never seen any kind of threatened job action with our organization, even in difficult times. Our organization's members were one of the first ones in our district to offer to give up wages and concessions to help meet some of the challenges we had with decreased revenue. The overall meet-confer process and the MOU has led to basically very good relations. We don't have any kind of provisions in there for any sort of job action. We don't have any provisions in there for any sort of sick out. We have a lot of faith, trust, and confidence in our firefighters. We were looking to basically upgrade our ordinance, or not necessarily our ordinance, but our process. And we looked at the city of Chandler because they essentially have the gold standard for a meet-confer process. And come to find out from the understanding that that was used as a template for this process. But a number of substantial changes have been proposed by various entities within Surprise City Management, City Legal, as well as HR. Just a couple of the provisions that I noticed in discussion here tonight. Upon promotion of a long-term employee to the next highest position, they become an at-will employee. That's unheard of in this valley. I saw that in here. You take a classified employee and they become a non-classified employee, or essentially an at-will employee. That, looking around the valley, that doesn't exist anywhere else. Some of the other provisions, there's already, personnel policies in our district. If there is a perceived sick out or any type of job action, our management structure is set up to take steps to, deal with those issues and deal with them in a corrective manner. As far as the breaches and disputes and so forth that may take place, we found that looking towards what a mediation process is, the federal mediation conciliation service may be a better option as opposed to an arbitration process. They do experienced mediation in the public sector, whereas the arbitration process through the American Arbitration Associations is mainly geared towards the private sector and private contract interests. So that would probably be a better one for as far as discussing any time of disagreement. So I guess that would be the
1 more minute if you need it.
That would be this 1 minute warning.
No, actually, that was the 3-minute warning.
The 3-minute warning. Okay, I didn't know what the
One
procedure
more minute if you.
One more minute. Yeah, so I would just like to say that a lot of concerns that have been brought forth from my perspective as a fire district board chair who has been dealing with this for the years I've been on the fire district and existed before my arrival. It's been very effective. Across the valley, it's been very effective, and I think some of the concerns and issues that have been brought forth are overreaching and unwarranted. And I thank you very much for allowing me to address you about our experiences in our fire district.
Thank you.
Mike Planetta.
Good evening, Mayor and members of the council. I'd like to reiterate what Brian was saying here. First of all, I have to agree with you. It's important for you to get this information ahead of time so that you can see what you're dealing with. So it's really important for you guys to get that information. But here's an example of, I'm a 25-year veteran of the Phoenix Fire Department, and I've been a resident here in Surprise for 23 years. So you can imagine how much I've seen our fire service change in the 23 years I've been here. The Surprise Fire Department right now is as good as any department in the valley. We all train together. We all go through the academy together. We have mutual aid, which is the best in the country that we have right here in this valley here. But this is the Phoenix Fire's MOU. It's very simple and very effective. This is something that I don't understand why we don't have this here. I just recently found out that we did not have this here. And from my understanding, we are the only department in the valley that does not have an MOU. Part of the problem, too, that it's not fair for the surprise firefighters here to have to fight for their benefits that they have every year when if they had a contract with an MOU here, they wouldn't have to do that. And you all know that we've had 5 city managers in the last 8 years. So they come in with other ideas and other ways of doing things. This helps protect our firefighters here who do an outstanding job here in supplies. And we need to make sure that we take care of them because they're the ones that are taking care of us. They're the ones that are risking their lives to save our lives and save our property. And I think it's extremely important that you really consider the proposals that are going forward because they're certainly dealing in good faith with the city management here. So I just ask that you really consider the proposals that they have. You guys will be they'll be getting together with the city management here, and hopefully you guys. I'm assuming you're going to table the motion today, and let them get together and work through the issues that they have, and then move forward with this. So I appreciate your time. Thank you.
Thank you.
Thanks, Mark.
And Ken Wright.
Good evening, Mayor, Vice Mayor, and City Councilman. This is the first time I've had a chance to look at some of this. I'd like to make a few comments on it. The agreement that was presented tonight apparently only brings a mediator in after issues are unresolved, and then they submit a written report. I've been through mediation a number of times, and the mediator needs to be there while he or she can talk and listen to both sides of the issues that are being presented, not just hit cold with the unresolved issues, because the mediator needs to get involved in some what's called fact-finding, and so that they can intelligently participate in what's going on. So it appears to me that the entrance of the mediator into the system has been truncated, and so I think that ought to be looked at. Under item J, a breach of obligations under this language should be presented to a department director. That's not good language because department heads may view these breaches quite differently. Then you get into the discrimination thing. One department head applies it one way and one department head applies it another way, and then you get lawsuits or whatever comes out of that. I would suggest that the department director take that information to HR, and therefore they could develop a consistent response to these alleged violations. And I think that what I was talking about on getting the mediator early involved was what John said about discussions, was his words. And then under 376, there's a statement about the city manager or who acts on behalf of the city manager. That needs to be defined. Is that a department head or an assistant department head or the janitor? We need some definition there. Again, that's kind of arbitrary, who acts on behalf of the city manager. So we need definition there. And then under one part of the language, there's supposed to be a resolution when all the concerns of the association have been met. What about if management wants to submit some kind of proposal for a change in the agreement? That's not even mentioned in there, in the language that's up there tonight. Management also has a right to submit proposals for change. So that needs to be looked at. This thing needs to be cleaned up a little bit. Thank you.
Thank you. Mr. Vukanovich, I I offered you the opportunity to come back and speak if you wish.
The only thing I would request, could I put my comments earlier in the record?
Yes.
Thank you.
Thank you. Does that conclude all wishing to speak and call the public?
Yes, Mayor.
Okay, I close call to the public, and I don't believe we have need to take executive session in a workshop. So what we're going to do is take about a 15-minute break and come back at, let's see, 6:40 or so. This meeting is adjourned.